Good evening, and welcome to tonight's installment of the Daniel Webster Debate Series, my first event as president of this chapter. This series was founded on the conviction that the constitutional questions most deserving of public attention are also the ones most deserving of sustained, rigorous debate. Named for the great senator and advocate who argued some of the most consequential cases in the court's early history, the series brings together distinguished voices to examine the legal and structural questions shaping our constitutional order. Tonight's resolution, should the Supreme Court overturn Humphrey's Executor, sits at the intersection of originalism, stare decisis, and the ongoing transformation of administrative law. Nearly 90 years after it was decided, the 1935 precedent remains the principal constitutional foundation for independent agencies. Yet the court's more recent decisions in Seala Law and Collins have called its reasoning into serious question, and the scholarly debate over its continued vitality has never been more active than now with Trump versus Slaughter on the horizon. We are privileged to examine these questions with two scholars who have engaged them deeply, and under the guidance of Judge Neomi Rao of the United States Court of Appeals for the D.C. Circuit, a jurist whose scholarly and judicial work on separation of powers questions makes her an exceptionally qualified moderator for tonight's discussion. Before I welcome our former Director of Debates, Louis Pham, to introduce our distinguished panelists, I would like to congratulate Louis on his new role as one of the vice presidents of our chapter, where he will continue to build on his hard work overseeing the Daniel Webster Debate Series. Thank you.
Thank you all for coming. Judge Neomi Rao was appointed to the United States Court of Appeals for the District of Columbia in March of 2019. She graduated from Yale College in 1995 and the University of Chicago Law School in 1999. Following graduation, she served as a law clerk to Judge J. Harvey Wilkinson III of the U.S. Court of Appeals for the Fourth Circuit, and in the 2001 October term as a law clerk to Justice Clarence Thomas on the U.S. Supreme Court. Mark Chenoweth is the President and Chief Legal Officer of the new Civil Liberties Alliance. He served as the first Chief of Staff to Congressman Mike Pompeo, as Legal Counsel to Commissioner Ann Northrup at the U.S. Consumer Product Safety Commission, and as an Attorney Advisor in the Office of Legal Policy at the DOJ, and a law clerk to Danny Boggs on the U.S. Court of Appeals for the Sixth Circuit. He is a graduate of Yale College and of the University of Chicago Law School. Professor Harold Krent is the Professor of Law at the Chicago College of Law at the Illinois Institute of Technology. He graduated from Princeton University and the New York University School of Law, where he served as notes editor of the Law Review and earned several awards for excellence in legal writing. He joined the Chicago faculty in 1994, was appointed Associate Dean in 1997, and served as Interim Dean in 2002 before becoming Dean in 2003 and held that position until 2019. And with that, I welcome tonight's debate.
Great, thank you so much for those really nice introductions. It's a pleasure for me to be here. It's one of my favorite topics, independent agencies and Humphrey's Executor, and I'm really happy to be here with Mark Chenoweth, who you didn't note was my same year at Yale College and the University of Chicago Law School. So we have known each other since we were kids.
Younger than these guys.
Yeah, younger than you all. So we go way back. And I'm also happy to be here with Professor Krent, who's a great expert on a lot of these issues. So I'm just going to tee up a few points, and then I'm going to turn it over to our debaters. But I think it's interesting, you mentioned in the introduction Seala Law and Collins. I think that the Supreme Court in some ways gave one of the strongest indicators of what it thought about Humphrey's Executor in Free Enterprise Fund, which is a case that was decided some years before that. And in that case, the Supreme Court said that independent agencies like the Securities and Exchange Commission exercise the executive power. So they gave up on this Humphrey's Executor framework of quasi-legislative, quasi-judicial powers. They said independent agencies exercise the executive power. And that proposition was not one just held by the majority in Free Enterprise Fund, but one that was agreed to by all 9 justices. So I guess one question I have is, if independent agencies are in fact exercising executive power, which I think seems self-evidently true because they're obviously not exercising any other kind of power, then how does one justify them not being in the control of the president, who is vested with all of the executive power? And And, just some other questions that I think, I just want the audience to be thinking about as we listen to this debate. I guess the first one is, what is the right answer to this question of can we have independent agencies as a matter of first principles? Right? What does the Constitution require? Does the president have a removal power over all officers of the United States? If so, where does that come from? It's not explicitly in the text of the Constitution. Does it come from the structure of the Constitution, from the meaning of the executive power? What is the original understanding of whether there is a complete removal power? But then on the other hand, the president only has agencies and officers to the extent that Congress creates them, right? He has no officers to direct unless Congress creates offices. He has no agencies to direct unless Congress creates agencies. And Congress undoubtedly, under its necessary and proper power and its other enumerated powers, has very wide latitude to create agencies to help the president execute the laws. And given that important power of Congress, what limits are there on the way that Congress can structure agencies, including with respect to, of course, what we're talking about here, which is, it has the power to create offices. What kinds of limitations can Congress put on the removal power? Now, Humphrey's executor and the protections for what I like to call the historically independent agencies have been around for a long time. And so, of course, one question is, how does historical practice and settled expectations affect this question? Which is maybe a more specific version of the question of what do we do about stare decisis? And finally, I think both sides of the debate hopefully will say a little something about remedies, because if Humphreys is overruled, I think there's a question, can the Supreme Court just sever the for-cause removal protections for federal trade commissioners, just taking them away? Or does the whole agency have to fall? I don't think anyone is really suggesting that the whole agency would fall, but I think there's a question about why not. Congress gave independent agencies very substantial powers, but also made them independent. If you take away their independence, do the agencies just remain otherwise unchanged? I think that's a question for Mr. Chenoweth. But if Humphreys is maintained, and for instance, the court rules that Ms. Slaughter's removal was unlawful, can she be reinstated? It's really since President Trump came into office, and there have been a number of removals, that courts have for the first time suggested that reinstatement is appropriate for a principal officer that is removed by the president. So is that an available remedy if Humphreys were to be overturned? I think that's a separate question from the legal question. So those are just some substantive questions, both about constitutional meaning, historical practice, remedies, and I'll stop there. I'll probably have some more questions after the debate, and hopefully you all will have some questions as well when our speakers are done. So with that, I will turn it over to Mr. Chenoweth.
Thank you, Judge, and thank you very much to all of you for inviting me to speak at Georgetown Law School today. It's an honor to be here. As you may know, we have several Georgetown Law alumni at NCLA, including our General Counsel, Jeanette Brown, and our Vice President of Communications, Joe Martiak, and my predecessor participant in the Webster debate series, Senior Litigation Counsel, John Vecchione. And that's not all of them either, we had a couple others. Following the oral argument in Trump v. Slaughter, there's little doubt in my mind that Humphrey's executor is headed for the ash heap of history. I don't think that's a bold prediction. However, when I'm done explaining the case today, my goal is that you will be rooting for the reversal and happy to see it happen. The Slaughter case poses a few questions related to tenure protection for commissioners at independent agencies. First, whether the statutory removal protections for members of the Federal Trade Commission violate the separation of powers, and if so, whether Humphrey's executor should be overruled. And it does contain the second question, whether a federal court may prevent a person's removal from public office, either through relief at equity or at law. I'm not going to talk about that in my opening comments, but I'm happy to address that in the Q&A. Since today's debate focuses on whether it's time to overturn Humphreys, I really want to focus on that separation of powers question and whether tenure protections violate the separation of powers via Congress impinging on the executive's removal prerogative. I think there are three strong textual arguments that militate against restrictions on the president's power to remove executive officials. Several of the justices focused on these arguments during the oral argument on December 8th, but I think it was Justice Barrett who really called out these three textual arguments as the key ones. First, the vesting clause of Article 2 states, the executive power shall be vested in a president of the United States of America. That may sound pretty innocuous, but my boss, constitutional law professor Philip Hamburger of Columbia Law School, has pointed out there are twin supports in the vesting clause for the president's removal power. Not only does the clause vest the executive power, i.e. one whole continuous power that is not chopped up but is undivided, but it also vests that power in a president of the United States, that is, in one single person. The president has all of the executive power, so anyone else exercising executive power doesn't have their own executive power. They are exercising a portion of the president's executive power. So if the Constitution gives all of the executive power to a single person, and executive power includes removal power, then absent some kind of clawback, the vesting clause bestows removal power on the president too. I should add here that no one seriously disputes that removal power is a form of executive power, even though there are other ways to remove someone that do not involve the executive, such as impeachment. There is some historical debate whether at the time of the founding the executive power was always understood to necessarily contain removal power, but I think it's fair to say that the consensus view is that it usually, most people thought that it did. The second textual argument in support of the removal power is the Appointments Clause of Article 2. Now, the Appointments Clause does not bestow removal power, but what it does do is put constraints on the president's appointments ability, while the rest of the document says nothing at all about the removal power. It is silent. This is Arthur Conan Doyle's dog that did not bark. By constraining the appointments power and saying nothing about the removal power whatsoever, the argument runs that the Constitution does not restrict the removal power. At the very least, it's fair to say that the Constitution could have restricted the president's removal power, but it didn't. But I think we can go a step further than that. We know that the founders considered the possibility of putting restrictions on the removal power. It's not like it didn't come up. It did, not for a long time, but it did come up. But the framers ultimately bestowed all executive power on a president without placing any restrictions on the removal power. That has to mean something. The third textual hook for the removal power is the Take Care Clause. This is maybe the most familiar to those of you who have studied constitutional law, as it requires the president, it says shall, to take care that the laws be faithfully executed and shall commission all the officers of the United States. The upshot of the Take Care Clause is the president has a solemn obligation to enforce the laws, and in order to do that, he has to have the control of the executive branch, or at the very least control over those folks in the executive branch who are exercising executive power, who are helping to execute the law. Those who are wielding his executive power, which the modern FTC inarguably does, as it brings its own cases in federal court. That is quintessential executive power. As an aside, even if the 1930s FTC only exercised quasi-legislative and quasi-judicial power, which I think is not true, but that's what the court said back then, Congress greatly increased FTC's power in the 1970s to the point that it absolutely exercises executive power today. So, as we pointed out in our amicus brief, it even enters into foreign agreements of various kinds, and there's not more executive power than that, right? So, even assuming Humphrey's executor were applied to the letter, Slaughter would still lose because, as should anyone else suing over being fired who actually exercises executive power, because what Humphrey says is if you don't exercise executive power, then you can have the removal protections. But she clearly does, and so do most of the commissioners of these independent agencies these days. So even without overturning Humphreys, they can be fired. But in any event, ultimately, if the president cannot tell someone, you're fired, then he cannot ensure that a stubborn subordinate does his bidding in executing the law. At oral argument in the somewhat similar case of Trump v. Cook, Paul Clement gamely tried to suggest that the president could impeach a Federal Reserve governor who was misbehaving. Maybe. But there are at least four problems with that, with making impeachment the president's sole way to remove a federal official. Lack of dispatch, the House or the Senate might be controlled by the other party, Even if it's not controlled by the other party, good luck getting 2/3 of the vote. And as Justice Barrett pointed out at the oral argument, some of the legitimate reasons a president might want to remove someone fall short of high crimes and misdemeanors. Some of these problems are admittedly reduced on multi-member agencies. So, for example, suppose the president has 3 of his appointees who he thinks are perfect on a 5-member commission. Does he really need to fire the other 1 or 2 in order to ensure that the laws are faithfully executed? Arguably he doesn't, but that would only defeat the take care argument. The other 2 textual hooks still pertain. These textual arguments from the 1787 document were strengthened just 2 years later in the famous decision of 1789. I won't get into the details of that given time constraints, but I will point you to a nice piece Professor Joseph Postel of Hillsdale College wrote running down that history. I think it's worth reading if you're interested in this topic. In a nutshell, in setting up one of the early departments of government, the question arose about how that person could be removed from office. After some debate, James Madison prevailed in the vote not to require Senate assent to removal, and that has been the norm ever since until the administrative state came along at least. So those are the 3 strong textual arguments suggesting that removal protections do violate the separation of powers. Now let me make some practical points. First, think about what it would mean if the president could not remove someone. Early on, it wasn't clear that someone like the Secretary of State couldn't continue in office across administrations. I mean, even in recent years, there have been examples of folks holding over from one administration to the next. Dick Thornburg was Ronald Reagan's last Attorney General and President George Bush's first Attorney General. We take it for granted that a new president gets a new cabinet, but that's only because we already accept the removal power working as a background principle. The last set of cabinet officers resign, the new folks fill vacancies. But when someone refuses to resign, which has happened recently at some of the independent agencies, the president must have the removal power in order to fire them. Otherwise, the outgoing president can instruct his cabinet not to resign and force the incoming president to work with the outgoing president's cabinet. The cabinet members are not appointed to a term of years, but that can't be right. Now, I know what you're thinking. There aren't removal protections. Congress hasn't given removal protections to cabinet members. But that's an accident, right? The principle's the same. My opponent has to argue that Congress could give such tenure protection to cabinet officials. Imagine the nightmare that an unwanted holdover attorney general would entail. No way, that's not constitutional. Second, what about the holdover minority problem? This is related to the previous example, except it's actually been happening. At my old agency, the Consumer Product Safety Commission, in both 2017 and 2025, the chairman of the agency refused to step down. As a result, for the first 10 months of the first Trump administration and the first few months of the second Trump administration, a federal agency was under the complete agenda control of the party that lost the November election. That can't be right. Even if you like independent agencies, they can't be independent of presidential elections. The norm used to be that chairmen would step down. They typically only have 5-year terms, whereas other commissioners had 7-year terms. It made it sort of created less incentive to stick around for that maybe 1 extra year. By stepping down, the commission might be 2-2 for some period of time, but at least wouldn't be in the control of the minority. In 2017, at least, the minority passed several rules that the president did not support. Someone should challenge those rules as being unlawful. Note that the lack of a vacancy can create problems even if someone in the president's own party refuses to step down. Staggered terms at some agencies could prevent the president from ever appointing his own people. That could either be because the outgoing president makes new appointments right as he's going out of office, or perhaps the Senate majority and minority leaders conspire in some way to keep their prior appointees in place and slow roll any replacements. A lot of times there are provisions and statutes that allow people to stay for a year or more past the end of their appointment. Removal power ensures that the president gets to appoint folks at these agencies, and it minimizes some of the game played by appointees of prior administrations. In my view, the best way to solve nearly all these problems is to entrust the elected president with removal power, at least over principal federal officers, and arguably over inferior officers too. The civil service is a different topic perhaps we can address another time. But without presidential control over the officers executing the law in the executive branch, there's no way to ensure democratic accountability and self-government. The president must be able to control those stubborn subordinates and holdovers and people who think they know better. The bulk of the president's principal subordinates, such as his cabinet officials, already serve at will. If the president wants to change secretaries of state, as he did in his first term, replacing Rex Tillerson with my old boss, Mike Pompeo, then he has every right to do that. I have a hard time seeing how it's a problem for the president to exercise the same removal power over minor independent agencies like the CPSC that he exercises over major departments like the State Department. Indeed, if we care about self-government, and I assume we all do, and we appreciate living in a democratic republic, then we need to get away from the Wilsonian vision of control by unelected bureaucratic experts and back to control by elected officials like the president. So ultimately, the reason it's time to overturn Humphrey's executor, and the reason you should be happy if and when Slaughter overturns Humphrey's executor, is that it will mark a return to self-government. Thank you.
Well, I want to thank the organizers and conveners here at Georgetown, because you may not know this, but this is the third effort we've had to stage this debate. So that takes persistence and patience, and so I thank you all for that. And when you think about a constitutional issue, usually you think about it from different axes, and I'm sure that Judge Rao will do this all the time. You start with the language. We've heard a lot about the language of the Constitution, at least some of the language here. The language, in terms of what does vesting mean? Who knows what vesting means? What does the fact that the removal authority isn't in the Constitution might give us some pause to think that this was so important to the framers. Why not? There is an appointments clause. The appointments clause has some limitations on presidential authority. And indeed, all these kinds of problems with holdovers and things that were mentioned, maybe that's a problem that Congress has violated the appointments clause by having too long of a terms, or by insisting that the CPSC would have both Democrats and Republicans on the commission. So maybe that's a flaw from Congress itself. And indeed, if you think about just the language of the Constitution, the problem that the removal authority isn't mentioned, you might think that, well, Congress did think about the appointments clause, and for superior officers, the Senate had to give consent. That's why Alexander Hamilton and others thought that, okay, if the removal, then the Senate has to consent to removal of a officer. That's the kind of balance that was struck in that issue. And what's really interesting, and I'll come back to in a second, maybe I'll do it now, is the other kind of constitutional language that wasn't mentioned was the necessary and proper clause. Well, that's in the Constitution too. And if we have to accommodate president's authority over the executive branch, which I believe in, and I actually have some sympathy or empathy for Chief Justice Roberts' discussion in Settle Law and in Collins, that it's important to end free enterprise clause, free enterprise fund, that the president should be electorally accountable for major decisions of the executive branch come the election day. But we have to accommodate with that with Congress's power. And if Congress creates the office and decides what its functions are, who's eligible to be in that office, don't we want to give some kind of credence to Congress decisions that there must be some kind of limit, some kind of quasi-independence, which I'll talk about in a couple minutes as well. So I think it's difficult. We have to have some kind of accommodation. That's what was going on in the independent counsel case, which most of you know of, Morrison versus Olson. There was a limitation on removal of the independent counsel because there was a conflict of interest within the executive branch about how do we get any kind of investigation into wrongdoing, or at least alleged wrongdoing by executive branch members. Congress set up this independent counsel to sort of act as a check. And even though there was limitations on the authority of the independent counsel, the court said, well, we got to have the balance, and we strike a balance. Sometimes a restriction on removal will be unconstitutional. Sometimes it will be constitutional. All right, that's just a brief thing about language. What about practice? What about some kind of originalism that a lot of judges hold dear to their hearts? And obviously we as litigators talk about history all the time. The history was that there was lots of counterexamples from day one. The sinking fund that had to do with debt for America, the patent board, those of you who are at IP, that was independent. Entity deciding citizenship was independent. Independent individuals, private individuals, had all sorts of power in terms of fines, in terms of being able to file lawsuits, being preclusive at the time. State officials had authority to enforce federal laws, and the president couldn't fire state officials for doing it the wrong way. So there's all these examples from the founding, that very many examples that are inconsistent with this notion of not having an accommodation between Congress and the president. So, I think that if you think about it, if Congress says, oh, look, we want to have important sort of discussions about civil liberties, we create a Privacy and Civil Liberties Board, shouldn't we then make sure that that person can be independent because when a watchdog over the president. The same idea of inspector generals, the same idea of special counsel who's there to be a whistleblower over the federal employees being abused by their bosses in the executive branch. Don't you want to have some kind of information, make sure they're not sort of the puppets of the president who we're trying to check, right? So maybe the underlying checking authority of Congress is unconstitutional. But the Congress in many different ways says we want to make sure that the president's serving the public. And so we have inspectors general, we have the oversight board, we have the special counsel, we have, in fact, independent judging, which the courts accepted in Collins versus Yellens, independent judging because we don't trust judging if judges are paid and can be fired by the president who's being sued in the action, whether it's the tax court, the Merit Systems Protection Board, etc. So can we trust Congress and all these conflicts of interest to sort of say, hey, we really think that there should be some measure of independence there. All right, so what I'm going to say now is I think if you accommodate Congress, which wasn't mentioned before in the prior two talks, with presidential authority, it's a hard accommodation because I do think a removal authority is important, but you've got to make one, particularly when there's this evident conflict of interest that is confronting the executive branch. Independent counsel, again, inspector general, etc. So I'm going to make a suggestion. So I'm curious about your reaction to the suggestion because, yes, Humphrey's executor is going to be overridden or thrown out, but what is left? And I want to suggest perhaps a different path. The Supreme Court in a case called Arthrex, which I know you know quite well, decided to define principal officer status a little differently. And they defined it as final decision-making authority over those outside the executive branch. Maybe they didn't think too much about the definition, but that was the definition. And if that is tantamount to what a principal officer is, then we should rethink about to define your idea of executive authority, Judge, by saying, well, the executive authority really means in this unique sense, not anybody doing anything that Congress tells them to do, only those with the authority to bind individuals outside the executive branch. That's what the Supreme Court said in the Mistretta case, which had to do with the Sentencing Commission. It said that we can have the Sentencing Commission in the judiciary outside of the president's control because they don't have final decision-making authority. And if that's true, then what Congress could say is, all right, for those individuals, inspector general, special counsel, judging within the executive branch, whether it's ALJs, MSPB, tax court, etc., all those entities which have the power to make recommendations, bring sunlight to issues going on with the executive branch, those individuals are no longer should be considered superior officers. Those issues, those individuals, despite what Mark Chenoweth said, should be outside then the potential removal authority that you can derive from Article 2 for the president. So if we say that Congress can't limit those exercising final decision-making authority, can't limit the president's removal of them, we should step back and don't go too far and say at least Congress can say independent judging, independent checks, independent balances. That will restore more balance between Article 1 and Article 2, and it's absolutely consistent with the history from before the founding and during the founding, where the Congress and the presidents elected. Indeed, you may forget Marbury versus Madison, our most famous case, right, in the early jurisprudence. It was President Jefferson who respected the limitation on the removal of the justices of peace, which then led to the entire sort of struggle to begin with. He did remove those whose commissions were delivered. He only decided to try to block those whose commissions were not delivered. So with that, if you look at the language, I would suggest unclear, but it leans towards Congress's side. If you look at the structure of trying to accommodate congressional power with that of the president, I think there should be some limitations on the president's plenary removal authority. And of course, I think I mentioned the history all to begin with. So again, at least I hope what is post-Humphrey's executive then is a recognition that yes, for final decision-making over private parties, that's what we now understand to be this new executive authority. That can be in the presidential domain in terms of removal authority. But Congress still has a very important role to play And I think that's what we should continue to debate and consider deeply if you want to have a system of checks and balances. Thanks.
Okay, I think our format allows each of you to provide
2
a couple
minutes.
minutes of rebuttal, so we can start there.
Yeah, well, first I wanted to answer one of Judge Rao's questions, which was what happens from a remedies standpoint. I think the court will sever the removal protections. I think they've done it before. I think they can do it without much other violence to the FTC statute. It does raise the very good question that Judge Rao raised, which is, well, would Congress really want that? I mean, that's a whole lot of executive power that's now under the control of the executive, maybe, or actually it's a whole lot of legislative power, let's be honest, that's now under the control of the executive. Maybe some of the justices aren't very comfortable with that. Well, I think Justice Gorsuch would be happy to team up with Justices Kagan and Sotomayor and whoever else to take some of that legislative power and give it back to Congress and take it, and that's what I'd like to see happen as well. I was interested to hear the professor invoke Arthrex, because I do think that's a very important case in this whole context, but I think it's important for maybe a slightly different reason than he suggests, which is that Arthrex totally undercuts the distinction between principal and inferior officers, which underlies Morrison v. Olson. So it effectively sub silentio overruled Morrison v. Olson. I mean, they don't say it, but Arthrex did. And so if you want the full argument on that, my now retired colleague Rich Stamp had a piece in Law and Liberty about Arthrex sub silentio overruling Morrison v. Olson, which I think spells it out very well. In terms of the proposal for sort of moving IGs and special counsel and other folks into this realm of not really exercising executive power somehow, if Congress wants to do something like that, that's fine, but they can't locate those people in the executive branch, and they can't be exercising executive power. I mean, you can't have, for example, someone bringing cases in court if they are, which the special counsel does. So that can't be somebody who is outside of the president's control, because that's quintessential executive power. The other concern that I have time to mention anyway, is that judicial power can't be in the executive either. Congress doesn't have judicial power to begin with, so Congress can't delegate judicial power to the executive branch. It's not a non-delegation problem, it doesn't have it to begin with. But it does it all the time. It tries to assign judicial power to ALJs and other executive branch officials. Totally bogus. The Supreme Court has started to get that right with Jarkissi. It's starting to push back in the right direction of pushing these things back into Article III courts where they belong. And I wouldn't want to do something, which I think this suggestion does, to sort of interrupt the proper flow of judicial power back into the judicial branch. And remember, too, that if we try to say that those folks aren't exercising executive power because they're subject to some sort of approval or sort of higher executive authority, well, then you have an executive ruling on judicial cases, and we know for 200 years that's verboten. So I don't think that solution works.
Well, I want to hear what Judge Rao says before we go to questions and answers. But I just want to make a comment on the last issue about how radical a position Mark must be forwarding if he says there's no judicial determinations in the executive branch. Every agency makes judicial determinations. The tax court, right, and the Federal Labor Relations Authority and the Emeritus and Protection Board, they all exercise judicial authority. So that would mean saying we need to have some kind of Article III courts for every time some kind of judicial question arises. Now, maybe he believes that. I'm just suggesting that is a radical change that hasn't been honored in hundreds of years here in this country. But it would solve the problem because we both agree there shouldn't be executive branch meddling in judicial determinations, and I think Judge Rao, that's against the spirit of independent judging as well. So just wanted to point that out, and maybe that would be, we'll have a lot more appointments, which is good for you all, in terms of these new kinds of Article III types of entities. So with that.
Actually, I just wonder on that last point whether you are both talking about the same kind of executive branch adjudication. Because like the MSPB and that type of adjudication is just adjudicating the rights of employees of the government. So arguably they're just public rights of government officials. Whereas I take, Mark, your point to be that the problem really is adjudication of private rights. But I'm not sure, I mean, I'm just wondering if that difference matters to either of you, because there are different kinds of adjudication within the executive branch.
Yes, it matters, and I think Jarkissi gets to this point, right? It talks about the public rights doctrine. It all goes back to Atlas, well, not entirely, but Atlas Roofing is the big case from like 1977, something like that. They got this just wrong. And the Supreme Court's eventually, I mean, they said enough bad things about it in Jarkissi, they should have just overruled it. But I think maybe the parties didn't ask for it to be overruled. But in any event, that's where this is headed, is overruling of Atlas Roofing and restriction of the public rights doctrine to a much, much, much narrower scope than it has metastasized to over the last 45 or 50 years. And I think that's a very good thing, because it's not just, I mean, in Jarkissi, they were concerned about the lack of jury rights. There's no juries in any of these administrative agency proceedings. There aren't Article 3 judges, which means they're not independent judges, so that's a problem. There aren't the Federal Rules of Evidence. There aren't the Federal Rules of Civil Procedure. You don't have a right to exculpatory evidence, even if the agency, in the course of its investigation, finds evidence showing your innocence. There are no Brady rights in these enforcement proceedings. There's no right to secure witnesses for your defense, as there would be in a federal district court. That's another constitutional right that administrative agencies take away from you. So there's a whole bunch of problems with executive adjudication that sometimes get ignored. And Jarkissi, I think, really focused on the big one, which I think lack of jury rights is the big one. But all these other ones matter too. No confrontation clause rights in administrative proceedings. There's lots of things that we consider core Bill of Rights. I mean, at the new Civil Liberties Alliance, we joke sometimes that we call them new civil liberties, but they're the ones you know. They're the ones in the Bill of Rights. They've just been ignored by the administrative state for the last 50 plus, coming up 100 years now. So it's not that radical, I would suggest, to restore jury trial rights. But I agree with you that it will do a lot of violence to the way that things are done now, because they've gotten so far away from the design of the Constitution.
It's just two quick points. In terms of most of the type, with the Securities Exchange Commission, the Federal Trade Commission, the Federal Communications Commission, the rights they adjudicate are private individuals. So all the kind of judging within these agencies would have to change. Social Security Administration deals with the biggest agency adjudicator in the world. Obviously, that's private rights as well. So the question is, do we have to have independent tribunals for all those? All I'm saying is that would be a radical departure. And I don't want to talk too much about Jarkissi now. That's a different debate. I'm happy to do it, but you'd be bored. But one thing I do want to point out is another sort of thought process is one of the individuals that President Trump fired was head of, I guess, the Bureau of Labor Statistics, and he just tried to have an independent jobs report, let's say. Okay. Well, should Congress want to have an independent jobs report? Shouldn't Congress want to have an independent head of the Fed, perhaps? And who's making this, which I actually is unfair because the head of the Fed actually does exercise executive authority as well. But aside from that,
Wouldn't have to.
Wouldn't have to, though. I agree. So shouldn't Congress, if it wanted to, say we want to have independent jobs reports? We want to have some independent recommendation about the environment, independent recommendation about that. Call it in the ether. Call it in the executive branch. I think the president would rather have it in the executive branch than in the ether. But shouldn't we, Congress, have some independence to create these kinds of positions because they don't bind private parties? And I think that's what we really were talking about today in terms of the future after Humphrey's Executor is interred.
Can I ask you a question about that? You mentioned a few times having checks and balances, by which I take you to mean checks and balances within the executive branch, right? You want inspectors general, independent counsel, entities that are within the executive branch that kind of, shed sunlight or.
Or there's strong reasons for congressional independence for Congress making certain officers quasi-independent.
Right.
Right.
Right. And so if that's the case, though, so I guess what is the justification for putting that sort of function inside the executive branch as opposed to letting Congress just do it through oversight and through all the tools that Congress has to check? Like when we talk about checks and balances, it's usually Congress, the three departments of the government checking each other. But this idea that there should be an internal check, a check that's not controllable by the president, what's the best, like Congress may want to do that, but what is the constitutional justification for an internal check like that?
So this is an interesting question, which may get us a little bit off topic, but I'll just, a couple of reactions. I mean, if you think about from a presidential perspective, would you rather have somebody doing a jobs report who knows people that they're looking at, who can work with people, who can give them information, knows how we generate this information? Is it better to have them for Congress or for president? I mean, independent counsel is easy, right? You could never have an independent counsel who is working for Congress. That would be much more of an assault on the independence of the president than the independent counsel statute was. Or if you think of an inspector general, do you really want someone from Congress going around and talking to your employees and being there and being a watch person to make sure that if there's cost overruns or false claims, that they don't go internally first as opposed to the externally to the Congress? I mean, I would think that there would be some tension there and that it's actually more respectful to presidential authority to have some of these checking functions, if you will, within the executive branch, within that kind of milieu, as opposed to outsiders coming in trying to be more hostile. But that's just, maybe it goes the other way.
Well, it does allow Congress to kind of embed people who are not answerable to the president within the president's executive branch. And that is very much aggrandizing of Congress because they're limited.
But still can be removed for cause, and still better than someone from Congress demanding information.
Well, Congress does demand information all the time. They just may not get it. But I actually think another interesting thing that came up in this debate, I think you both agree, and I think many commentators and observers believe Humphrey's executor will be overruled. And so then there's this question, what happens to people below the level of principal officers? And I guess maybe a question for you is, can the president fire everybody kind of all the way down? What about the civil service, people who are employees? We, on our very elaborate emergency docket in the DC Circuit, have had a lot of interesting, we had the Slaughter case obviously came up through DC in which, I wrote a dissent, but there have been a lot of cases that haven't gone to SCOTUS about different levels of removal power. And so what happens there? What about employees? What about inferior officers?
What about the janitor, right? I mean, there are people who are employees in executive branch who don't exercise executive power. I don't think the president. I think it's fine to have civil service protections for those folks. I don't think that interferes with the president's executive power. There obviously picked the easy case. There are edge cases.
What about the inferior officers? So there are many statutes that say, okay, the president can remove a principal officer, but the principal officer has removal power over inferior officers. So there have been some interesting cases where the president has fired all the principal officers of, say, a board or an agency, and then fired somebody below that level, because there was nobody left to fire them. Can Congress limit the president's removal over inferior officers?
I think the answer is yes. No, I'm back up. I think that.
Well, the edge cases kind of do test some of the constitutional principles in a way, I think.
They do, but I misspoke. What I was going to say is I think given the definition from Arthrex and the fact that the Morrison v. Olson distinction between principal and inferior officers is no more, I think that the president can fire inferior officers. I think that the folks who I'm thinking about, is everybody in SES considered an inferior officer, senior executive service? Is
I
that
don't think those people are inferior
Not currently,
officers.
right?
No, I think those
So
people
that's
are,
maybe the edge case for me.
they're civil servants largely.
Yeah, I
And
mean,
they're overseen usually by political
Oh yeah,
officials.
yeah. And those are coveted slots typically in the agencies. Like even within, there's jealousy within divisions at agencies over how many SESs do you get and how many do you get and so forth. Because those are considered plum positions for sort of capstone civil servants, or they'll bring in really sometimes pretty highly qualified people to into those positions. General counsel of an agency sometimes is an SES, for example. They're not always
Yes,
presidentially appointed, Senate confirmed. So I think that's an edge case. I mean, at least when I was there at the CPSC, the general counsel was a political appointee, but that hasn't always been true. It's one of those positions that's gone back and forth for some reason. I think it's an interesting edge case for me. Anybody, like I said before, anybody who's bringing cases in court is exercising executive power. That's a non-starter for me in terms of the president not being able to fire that person. But there are agencies, and the CPSC is one of them, that don't have independent power to go to court. They have to go through DOJ. So there's room for some.
Kind of strange is one comment that Congress has authorized private individuals to go to court on behalf of the government from day one. And that was true in England as well. So that's kind of tough for your definition.
You're talking about key tam lawsuits?
And more than informers lawsuits, qui-tam lawsuits, in particular, others to get fines from smuggling and all sorts of stuff. But I think in terms of the answer to your question, since you're the judge, I think it's clear that if you think about the language of the Constitution, there's two categories of officers: principal, and the president should have more authority with principal, who he has to appoint by definition under the Constitution. But for inferior officers, Congress can make the decision whether to to vest the appointment authority in the president or into heads of departments. That would suggest they're lesser importance. They report to superior officers. And so if it's important, Congress can make the decision then to insulate them from plenary removal authority. That just seems like it's a logical, structural, and language interpretation of the Constitution itself.
So I think the text and the structure fight each other on this point, actually, because the text of the Constitution, you're absolutely right. It says that Congress can vest the appointment in the president, in the heads of departments, or in the courts. But does that mean that Congress can vest the ability to appoint Judge Rao's clerks in the president?
That's an example, by the way.
That can't be right.
I've used in class as well, but what the court has said about that in some cases is that they have to be some kind of symbiotic relationship or some kind of connection to make sure that those kind of cross-branch appointments make sense. Yeah, I agree that cross-branch appointments weren't dealt with in the Constitution, but I don't think that undercuts the whole idea of inferior officers within the executive branch. And clearly, I don't think anybody in the panel, maybe I'm wrong, thinks that the civil service is unconstitutional, but maybe somebody does. But obviously, and I think too, if you think just the civil service, think about doctors, think about architects, think about technology wizards, right? You can have an expertise and be important. It doesn't mean you have to be fired at will by the president just because you have this kind of expertise. So,
I don't think expertise makes you fireable. I agree with that piece of it. But if you're applying that expertise in a way that is inconsistent with the priorities and policies of the administration, I think you are fireable. I mean,
that's for cause.
If that's for cause, then I think that for cause loses its meaning. I mean, if for cause includes inconsistent actions to the policies and priorities of the administration, then okay, I can accept that.
Do you think
That's
for
fine.
cause includes that? Because if you think for cause includes that, which may be what the court decides in the
Cook.
case. I mean, a very broad understanding of for cause to mean like you're not following the president's priorities. That's basically at-will removal.
Well, I prefer that. I prefer that system. Absolutely.
Yeah.
I mean, I think that if you are an officer who is not following the president's priorities, I mean, as opposed to legal priorities, whatever. Yeah, I think they should. That's cause for discharge, right? If you're not prioritizing the right things. I heard a story coming over here about the FTC commissioner under President Biden who didn't follow the priorities of the president. And could that have been cause for a discharge? I think so. No one's mentioned here, there's even a stronger version of the unitary executive that hasn't been articulated tonight, which is, and I know some people will have it, which is that, the president can do it himself. It means that if Congress delegates authority, the president can actually go in and take the step. It doesn't have to be by the FTC head or et cetera. So we're all getting slightly shades of attenuation in insulation as we go down this road. But if you ignore a president's lawful order, I think that's probably.
You think that's, but then that just undermines the whole concept of independence, right? The whole idea is that the president can't tell them what to do and then can't remove them for them not listening to him.
Well, there's still a cost of discharge, right?
There's always a cost to removal. Removal is an imperfect tool, right? Because you may not get a person you like better, you may not be able to get someone confirmed, you may just have a vacancy. Like there are lots of. It's the removal is a big hammer, and it doesn't get exercised very often.
Although there's I'm sorry.
Yeah.
There's one particular example that some of the things we were talking about are more hypothetical, but there's something that's happening right now that people may or may not be fully aware of, and that is the appointment of U.S. attorneys by federal district courts. And this issue might come up in front of Judge Rao at some point, so I don't expect her to comment on this, but it's sort of shocking. So the statute's been around for 150 years, something like that. This isn't new. But it is cross-branch appointment, right? This is members of the judiciary appointing a prosecutor. Again, like I was saying before, quintessential executive power. Boy, that seems problematic to me, and not clear to me that U.S. attorneys are inferior officers either. Now, that there are two schools of thought on whether U.S. attorneys are principal officers or inferior officers, but they are. Most of them are presidentially appointed and Senate confirmed. That's usually what we think of as principal officers, right? Mm-hmm. So what's happening in these cases is that the president's choice isn't getting confirmed. The president's second choice is getting timed out of being in the office temporarily, and then the judges are appointing someone. Now, historically, what happened a lot of times is the judges would go ahead and appoint the person that the president wanted. Once that happens, there's no incentive for the president to continue to seek their confirmation by the Senate. That might be an appointments problem right there. You're going around Congress because you've got the executive branch and the judicial branch agreeing, that prosecutor's good enough. We don't need Congress to be involved here. There's a whole lot. I think it's a very fertile area to think about and write about. And if folks are looking to do student notes or something like that, I just think it's a because of the way that it's happened in this administration where the president's really been fighting that, and in terms of removal power, he's instantly been firing the people that the judges have appointed to be U.S. attorneys as well, using his removal power authority, and that hasn't been challenged yet. There's a lot.
So that's a good example of where even under a loose definition for a cause, they wouldn't have cause to discharge the interim U.S. attorneys. I'd love to hear you guys' questions. So I will shut up and see any time to you all.
Yeah, happy to take questions. Yeah.
I'm just wondering, following if and when Humphreys is overturned, will the next challenge then be the constitutionality of like a bipartisan agency structure, like an agency that says, okay, we have 2 Democrats, 2 Republicans, you always have to have an even balance. Like, is that then the next step following Humphreys, or?
Maybe. I think that the FEC has 3 and 3, right? So that's the one
We'll have to see what challenges NCLA decides to bring next.
To me, it's not the partisanship so much as it is the presidential control piece of it. I'll just give you guys a little bit of insight, having been a legal counsel to commissioner at an independent agency. Ann Northup thought that it shouldn't be a multi-member commission. She said, this is ridiculous. The chairman should just run everything. The rest of us are sort of irrelevant. I actually didn't agree with her on that point. didn't publicly disagree with her at the time, of course, but the advantage to having minority commissioners at these multi-member agencies is that they know where the bodies are buried, right? I mean, you talk about having IGs or somebody, you know who really knows what's going on at the agency? The minority commissioners. They know because they have instant access to all the SESs. I mean, they get weekly briefings with all the senior people, the general counsel, the head of enforcement, whoever they want. They can go and talk to those people anytime they want to. They're the chairman of these independent. I don't know if you guys know this. The chairman of an independent agency is a co-equal with the other commissioners. They don't run the agency. They have to get a majority vote on even things within the agency, like hiring people and things like that. So it really is a multi-headed agency. And in addition to knowing where the bodies are buried, you also get to write dissents, which is one of the most fun things about the job. Maybe the only fun thing about the job, if you're a minority commissioner or working for a minority commissioner, and those dissents can really tee up lawsuits against the agency by pointing out all the ways in which what the agency has done is legally defective, right? So you don't get that in a single person-headed agency. So I think there's some, and obviously that goes both ways, regardless of whether it's Republicans in the minority or Democrats in the minority. I think there's some advantages to that. I see why Congress likes it. I just don't think that they can be exercising executive power against the president's wishes.
I think as a practical matter, some of the independent agencies the chairman has a lot of power. Like in some agencies, they do have all the hiring power and they have a lot of agenda control power and they
For sure.
Yeah, and they operate sort of like CEOs of the multi-member agency. Now, like the appointments power isn't always enough. Just because the president has 3 out of 5 members doesn't mean his position will always prevail on these multi-member commissions. But there have been some interesting articles about how functionally independent agencies, like how independent have they actually been. And at various points, presidents have indirectly exercised a fair amount of control over independent agencies, which if you have a strong view of the executive power, it's fine. But if Humphreys is overruled, that sort of control will be much more visible, which I guess there's a transparency aspect to it. It's not just the president calling the chairman of the FCC and saying, do net neutrality, and which is what happened in the Obama administration, right? The chairman of the FCC said, I'm not doing net neutrality. The president's like, we're going to do net neutrality, and the chairman changes his mind, which I think is actually appropriate, right? It's his administration. But that type of control varies a lot as a practical matter. And if Humphreys is overruled, then there'll just be much more transparency. The president will be on the hook for whatever it is that the so-called independent agency.
I just said we shouldn't cite the fact that if you're an effective politician and an effective president, you don't really need appointment and removal as much as your tools, because you can do it through suasion and loyalty and all that kind of stuff. But I do think that restrictions on the appointments authority are inconsistent with the stronger version of the unitary executive, as that question suggested, right? Because the president can't have the people in charge of that agency that the president wants. Somebody has to be learned in law, somebody has to be a Democrat, somebody has to be, whatever that restriction is on the office.
I mean, my boss was appointed by Obama, right? I mean, even though she was Republican commissioner.
Right.
So if Humphreys is overturned, where should we draw the line between who's fireable and not by the executive branch? Should we include the Fed Reserve? And if so, if the president can fire someone in the Fed Reserve, how do we ensure that anyone has confidence in the U.S. dollar?
Well, we can't, right? That's the whole point, right? The whole theory of why the court, I think, right, said what they did in the Slaughter case so far is because they think that it would be bad for the country to have a non-independent Fed. Why? Because monetary policy then can be served for political ends, right? We need to have quasi-independence there, and I'm just suggesting quasi-independence is not only good for the Fed, it can be good in other contexts as well. So what we really need is, kind of a, sense of where, and that's why I tried to tee up, is where quasi-independence was really so important for the country that we want to allow Congress to have that marker And where it's not, it's overridden by this need for the president to have close control.
It's always interesting to me that people have so much confidence in people who are wholly independent from any democratically accountable
Wholly
official.
independent?
Well, I mean, well, who does the Fed answer to? If you take a strong form of Fed independence, who does the Fed answer to?
Move for cause.
Yeah, we'll know more after the Cook case, right? As to what counts
the
as.
SG made a smart move to challenge the Cook removal, to defend the Cook removal only on statutory grounds, having observed that at least some members of the court are skittish about having constitutional independence for the Fed.
Well, and let me take a shot at your question. So, the reason that we do what we do with the Federal Reserve is we've created what is called the Ulysses contract. I don't know if that's a term that people are familiar with, but if you're familiar with the story of Ulysses, right? He puts the wax in his ears, or excuse me, he does not. He gets lashed to the mast. Everybody else puts the wax on their ears so that they can sail by. I guess it's the sirens. He wants to hear the siren song, right? So the idea is that and he says, no matter what, like don't listen to me, don't release me, don't. Well, he's committing in advance to something because he knows that what he's going to do in the moment is not the right thing to do. Well, that's what we're worried about with interest rates. In the moment, we're concerned that a president for populist reasons or a Congress for re-election kinds of reasons is going to screw with interest rates in a way that's going to cause massive rampant inflation and be bad for all of us. And so we want to take that power away from them, right? That's the whole point. It's the Ulysses contract. Now, what we said in our amicus brief in the Cook case was, okay, fine, but the Fed doesn't then have to have regulatory power, which it does. You could separate those two things, and Congress should separate those two things, and just have the interest rate setting piece be over here, and the bank regulating piece be over here, and the president absolutely needs to be able to fire the people who have standard executive branch regulatory power. Now, unfortunately, I don't think the court, and you remember the question before, I don't think the Supreme Court can do that. I think that has to take an act of Congress to make that happen. That's what should happen. I think if the court decides that the president cannot fire Lisa Cook, we're not going to get that solution. If the court decides the president can fire Lisa Cook, that bill gets introduced the next day.
And also the Fed, historically the Fed has not had a lot of regulatory power. Its regulatory power has increased over the last, 20 years. Dodd-Frank was the primary bill that gave the Fed a large amount of regulatory power. So it's not as though you can't have a Fed without regulatory power. Its regulatory powers are relatively recent, in any substantial form. I think that's historically fair to say.
But just to point out quickly, then it's coming upon all of us, particularly the judges, then to figure out a line between how you define what executive type authority can be insulated, as I've been mentioning, from the president's removal authority, and because monetary policy is important, right? It's really important to the administration what the monetary policy is. Why is that something that can be severed off unless we go back to some kind of decision-making outside the executive branch that I suggested Mistretta and Arthrex might support. Because monetary policy is really important, just ask the president.
There's also an empirical question whether the Fed is independent. And there's some pretty good empirical work that's been done to show that the Fed has a very accommodationist policy in the run-up to Democrat re-elections for incumbent Democrat presidents, and it doesn't for incumbent Republican presidents. So, take that for what you will, but independent Fed, maybe.
Yes, in the back.
This isn't exactly about independent agencies, but I wanted to get your take on the Senate blue slip process. Do you think that there could potentially be a separation of powers issue when a sitting senator essentially has veto power over the president? And could there ever be maybe a lawsuit that could overturn this process?
So I worked at the Office of Legal Policy at DOJ, so dealt with the blue slip process for, I guess, 18 months or something like that. I don't think it's a separation of powers. I think it's just part of the Senate's legitimate participation in the process. There are aspects of it that I think are great. There are aspects of it that I think are not great. but I don't think it rises to the level of a separation of powers problem. It's interesting because there are courts where the blue slip process doesn't come into play, right? Like the DC Circuit.
No senators in DC.
Yeah. I think the test would be if you had, if suppose the only vacancies that happen are in blue states under a Republican president or in red states under a Democrat president, and you have essentially the McConnell strategy to the Scalia seat applied to every single vacancy. Like we're not approving anybody. Well, there is a constitutional answer to that, at least if the Senate goes into recess. You could have recess appointments. That has happened even at the Supreme Court historically. But if the Senate were doing that strategy, presumably it wouldn't go into recess, and you'd have a bit of a conundrum.
Yeah, I'm not sure I have an answer to that question directly, but one way to think about the blue slip policy, to the extent that it's even still very robust, which I'm not sure that it is that it is a way for the Senate to exercise its advice and consent power, and the Senate as a whole decides whether to honor or not honor blue slips. So in some ways, it's kind of an internal rule of confirmation that the Senate uses to exercise its confirmation power, right? And so it may have the effect, if the Senate respects blue slips or has a blue slip process that senators uniformly respect, it could have that effect, but that is a function of the Senate as a whole setting those rules. So, I mean, that's just maybe another way to think about how the blue slip works.
And I'm not sure who would have standing to bring that lawsuit, by the way. Not the few that
Disgruntled
appointee.
families.
I don't think they have standing.
A disgruntled nominee
I don't think so.
said I would have gotten.
You don't have a right. You don't have a right to the
I mean,
office.
internal
would be
rules
the-
of the
the
Senate
argument.
and the House are, virtually beyond judicial challenge.
Pretty hard.
It'd be really hard for someone to have standing to challenge a House or Senate rule unless it was in some way.
I mean,
Very hard to get standing to challenge a House or Senate rule. I'm
I
not saying it's
suppose-
impossible, but it'd be difficult.
Not even the House would have standing to challenge it because they're not involved in the process. So I don't think they can claim because there's one house, there's single house standings. Arguably, some people think. Not for that though.
Congressional standing, another really interesting issue.
So we talked a little bit earlier about, the idea of what for cause removal looks like. And, if we were to stipulate for a moment that that looks like going against what the president's objectives are, perhaps. Like, I could see the Federal Reserve, if they were engaging in certain types of quantitative easing to, effectuate certain economic outcomes which go against the president's, under that circumstance, wouldn't that basically look like, he's basically getting his policies being interfered with, and that's defeats the whole purpose of for cause. So I guess I would just be curious what people actually think the for cause removal should look like. How much leeway should people have to go out to kind of defy or de facto defy the president's wishes? And the same, I'm just saying, could go for the civil service too. If they're kind of engaging in mission creep that hurts the president's agenda.
Yeah, no, and I think that if you say, it's got to be a lawful order, first of all. So I'm not so sure that you would say that the president has the ability to say quantitative easing or no quantitative easing. So that's why I just disagree a little bit, with others. So I do think, but I mean, if you're go back to the FTC, since we've talked about that in the Executor, if you say, this is what I think we should do about non-compete clauses, since that was a big issue a couple of years ago, right? And the head of the FTC says, well, that's interesting, but you can't tell me what to do, at least in an adjudication. I would say that's not for cause to do that, but if you say something like you have to show up, I don't know, and work overtime, you have to show up, come into office 5 days a week, which Musk was planning to have the federal government do, then didn't. That certainly would be, I think, legal, and you could fire somebody for not doing that. So I don't know, in between those two, I'm not exactly sure how it falls, but I do think there's a realm that the presidents can say, I have a lawful ability to say, show up to work. I have a lawful ability to say, you're not doing enough adjudication. I have a lawful ability to say, you need to stop and do a rulemaking as opposed to an adjudication. I think maybe that's all appropriate, but we don't know because the courts have not gotten into this at all.
What would you think if the president said, Fed, you set interest rates however you want. That's fine. You're independent. I'm going to use my power to mint money, working over here with the Congress. I'm going to mint a $1 trillion coin.
I thought he did that. No.
They were talking about it. I mean, this was a serious proposal at one point, right? I mean, so, I mean, there are workarounds, I guess is my point.
Where do you spend that coin?
You just put it in $4, I think.
I guess.
Go ahead.
I think we're almost, are we out of time here?
We have one more question.
Okay. Is there one more question? Okay. Do you guys have any final thoughts?
I had one small story, I guess, that I wanted to tell, because Professor talked about expertise at these agencies, and it's just my favorite expertise story that I tell from my time at the CPSC, because I think expertise is the underlying claim for why we need independent agencies. People, sometimes they say it, sometimes they don't, but they like, oh, we gotta have the experts. Well, you have to remember that the experts aren't in control at the agency. It's the bureaucrat politicians at the top of the agency that are in control, and they have the power to listen to the experts or not listen to the experts. And the best example I have of that is we were implementing something called the Virginia Graham Baker Pool and Spa Safety Act. James Baker's granddaughter, I believe it was, died in a tragic spa accident, and because it was who it was, the Congress jumped into action. And it's true that about one person a year was dying in a pool or spa safety accident. It was often, you guys have seen pool drain covers, right? Through sort of honeycomb on top, whatever. About once a year, either someone with long hair or someone wearing long jewelry would be entrapped and would die, or in some cases, you'd have a young kid sitting on there or getting their stomach trapped on it. I mean, there's some gruesome examples of it about once a year. So Congress passed the law, the agencies looking into this, and the scientists of the agency say we need to require double drains in every pool. That'll cut the suction power in half, and that'll solve the problem. Completely true, that solves the problem. They put it out for notice and comment. There was a brilliant female scientist who came in and testified and said, I've got a much better solution, and it's going to cost about $20 per drain. And she showed the design of her pool drain cover, which fit inside of a standard pool drain cover, but it was about this big around. The suction only came around the outer edge, and there were channels that came in from the outer edge all the way to the center. Absolutely no way for hair or jewelry to get entangled. You could sit on the drain, no problem at all. Completely solved the problem. The scientists at the agency were dumbfounded. They're like, that's brilliant, and not only does it work for new pools, but like, who wouldn't spend the $20 to get a new drain cover to solve the problem on an existing pool? Like, this is a really good idea. So they put it to a vote of the commission, and the two Republicans voted in favor of that, and Bob Adler, one of the Democrats, voted in favor of that. And for whatever reason, the consumer groups went absolutely nuts, and they hated this vote, and they put pressure and pressure and pressure, and they got Bob Adler to split his vote. And so that solution was not the solution that the agency endorsed as being consistent with the statute. So there is expertise at the agencies. It's not always the best expertise, and it doesn't always prevail. And so it doesn't mean we don't want to have expertise at these agencies, but I don't think that you can just say, well, we need expertise, therefore we need independent agencies, because the independent agencies ignore the experts a lot of times too under the existing situation. So just sort of tales from the crypt, if you will.
In my last sentence, it's not a tale from the crypt, but it's just, if we think about Chief Justice Roberts' comments that we want to have these removal authority because we want to make the president accountable come election day, then I want to ask you to think about what kinds of decisions we want to hold the president. We want to vote for the president based on what kind of decisions. What are those kinds of critical decisions, whether it's pool covers, spa covers, or whether it's fines meted by the FTC, et cetera, et cetera. And I think some of the things the executive branch does now, we don't care what the Inspector General says. We're not going to vote for the president. Maybe we'll vote for the president if he ignores the Inspector Generals. We're not going to vote for the president depending upon what the Inspector General says, or depending upon what the FTC says in an adjudication, and so forth and so on. So this electoral accountability is, I think, a helpful lens for the unitary executive and for the removal authority, but it goes a little too far given what some people say from the unitary executive. So again, I think lines between Congress and the executive branch must be accommodated.
Okay, well, please join me in thanking our debaters.
Thank you.
Thank you, Judge. On permanently on.
Yeah, thank you. There's the least we can do after
Oh.
after all that happened.